The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your sometimes bi-weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by IJ Senior Attorney Paul Sherman, as well as one of IJ's newest attorneys, Patrick Giacomo. Patrick, welcome to IJ and welcome to the podcast.
Thanks, I'm thrilled to be at both.
Patrick has the distinction of being a Short Circuit listener before he was hired to work here. So for the lawyers and law students who are listening, please be inspired by Patrick and check out the Employment Opportunities section on IJ's website, where you will see both open positions for students and attorneys. Patrick, let's kick things off in the 10th Circuit.
So I'm going to start by talking about the case Leck versus the City of Greenwood Village. This is ostensibly a takings case, but it's a fact pattern that's a lot sexier than your typical takings case. This is really a story about a hammer in search of a nail. So what happened was a bad guy stole 2 shirts and a belt from a Walmart in Aurora, Colorado, which is a suburb of Denver, and then fled in a high-speed pursuit to the much smaller town of Greenwood Village, which has about 15,000 people in it, where he broke into a home owned by the Lecks, and then a 19-hour standoff with the local police department ensued. Now, what makes this case particularly interesting is that the 15,000-person town of Greenwood, Colorado, has very sophisticated military-grade equipment, including a Bearcat armored personnel carrier, and Bearcat means ballistic engineered armored response counterattack truck, gas shells, a robot, and explosives. So after 4 hours of attempting to negotiate with the suspect inside the home, the Greenwood police effectively decided that they would simply destroy the house to get at the suspect, and they did this by, among other things, driving the Bearcat through the front door, using explosives to blow holes in the side of the house, firing gas canisters into the home, and basically, I think one of the police said, doing anything that wouldn't make the roof fall in. And the purpose for putting these holes in the house was, among other things, to give a sightline for snipers.
Yeah, if you search for this case online, you can see photographs of the house, and it is just absolutely wrecked. Huge holes blown through all the windows. I mean, this place is destroyed.
Right. You can't overstate what the police did to this house. And essentially, they took a lot of equipment that I don't think was meant to be used in the way they used it and kind of MacGyvered it to blow up the house. The explosives I think they had were meant to be used as destroying other explosives. So if a bag was found somewhere with a bomb in it, they could blow it up. But they were able to re-engineer it and blow holes in the side of the house. After 19 hours, they were able to send in a SWAT team and apprehend the suspect, who, again, had stolen 2 shirts and a belt from a Walmart. Meanwhile, the homeowners stood by and watched their entire house be destroyed. And so the legal issue in this case comes in when the homeowners asked the city to pay for the enormous amount of damage that they've done to the home. And the city said, essentially, we'll give you $5,000 for temporary living expenses, but other than that, you're on your own.
Yeah, and to be clear, their position was, we're giving you this $5,000 just as like our grace. We're not required to give this to you. We're just trying to be nice people, and you're on your own.
Right. We're just nice guys. And this is one of those cases that as an attorney, you have a lot of these moments sitting at your desk where you're thinking about the other side in a case, and you just say, why can't you just do the right thing? Why does everyone have to find some point of leverage in litigation? Why can't you just realize what you're doing is bad and not do bad things? But that's probably asking too much. So the Lecks filed a lawsuit against the city and a bunch of the officers involved, and essentially said that the destruction of their house was a taking under the Fifth Amendment of the U.S. Constitution and the Colorado Constitution, which says that takings for public use have to be justly compensated, and promptly lost in the district court. And the case made its way all the way up to the 10th Circuit, and the 10th Circuit effectively affirmed the district court's ruling and said, no, this isn't a taking. This is the use of police power, not eminent domain. And so the government doesn't have to give you anything if they destroy your house. And that's true even if they destroy your house for a public purpose, like catching a criminal fugitive. They did this, in my opinion, on a very flimsy basis by essentially borrowing case law from the realm of regulatory takings. And regulatory takings are typically a situation where government regulation put in place limits or prohibits you from using your property in a certain way. a case like this in the 10th Circuit and certainly in the Supreme Court has never involved a physical taking or destruction of property like it did in this case. And the real frustration with this is, although there's some way to explain by analogy why regulatory taking makes sense, if you go back to the U.S. Supreme Court case that's the basis for all this in the regulatory context, it's a case from 1887 called Mugler versus Kansas. And there, Kansas had put in some sort of law that prohibited you from making or selling beer. And so these guys who had made $60,000 worth of beer said that was a taking. And the Supreme Court said no, because it was regulatory, that, quote, such legislation does not disturb the owner in the control or use of his property for lawful purposes, nor restrict his right to dispose of it, but is only a declaration by the state that its use by anyone for certain forbidden purposes is prejudicial to the public interests. And here the obvious difference is that by destroying someone's house, you have taken it away from them and they can no longer use it or dispose of it.
That quote was kind of a mouthful. Can you just kind of walk us through, in plain English, that not 1800s English, what was going on in that case?
Sure. So in that case, like I said, there were one or two people who had made a bunch of beer, and Kansas passed a law that prohibited people from making or selling beer. And so they said, well, we have $60,000 worth of beer, and now Kansas says we can't do anything with that beer. And so that is a taking because you've said essentially we can't use our property. And the Supreme Court said, no, it's not really a taking because you can still use your property. You just can't use it for unlawful purposes. You still have the right to use it or dispose of it how you'd like.
Yeah, so you can pour the beer down the sink.
Right.
You're allowed to do that. You could drink it, but you can't make any money off of it.
Correct. And you might agree or disagree with whether that is it actually a taking that needs to be compensated. But what I think everyone should be able to agree on is that that's a far cry from using explosives in a tank to blow up a private family's home because a suspect was inside it. But that's where we are. And so the Lex are basically out of luck, according to the 10th Circuit and the lower courts.
Yeah. So, one of the central issues in this kind of case, and also in other takings cases, is when the government wants to achieve an objective for the public good, should the cost of that be borne by the public at large, or can it be borne by just whoever has the bad luck of being in the government's way? And so when we're talking about a traditional taking, the idea is, well, if we want to build a highway here, the public should have to pay for that. That cost shouldn't all fall onto the homeowner who's having their home taken away. It seems like that logic should apply with equal force here, where, if the government wants to enforce the law against shoplifters in this incredibly over-the-top way, well, that imposes costs on society. Who should bear those costs? Should it be the taxpayers who have to pay for the damage caused by police? Or should it be the property owners who have their property destroyed? I think if we put that burden on the taxpayers, we would see a stronger incentive for voters to curtail that kind of activity by the police.
Right. And actually, the Lex made precisely that argument to the 10th Circuit. And they basically said, no, when it's the police powers, it's okay for us to essentially privatize the costs and publicize the gains. So if it's that the person who happens to run into your basement, then it's on you when we blow your house up.
So make sure you have homeowners insurance, I guess, is the takeaway from that.
Yeah, it's actually funny because I saw on Twitter that the city of Greenwood, Colorado Village had actually put out a press release after this came out, essentially celebrating the win and saying, well, the Lex, they have property insurance, so this is no big deal. And it was basically inappropriate for them to ask for us to pay for it anyway for that reason. And I don't understand why they think that that's a compelling position to take. But even if it were, any money that the city would give to the Lex, I presume, would go to the insurance company anyway to offset what is paid out for the destruction of the house. So, it's a frustrating precedent, and it's sadly not the only case across the country where something like this has happened. In fact, the 10th Circuit relies heavily on a D.C. Circuit case where something similar had happened. That right now the state of the law is that if you're sitting in your living room watching TV and a criminal comes running in, then you better just hope that they give up easily and that the police don't have a bunch of toys that they probably got from a DOD grant that they've been itching to use.
Paul, let's move things on to the next case now.
Sure. So this is also a property rights case. This is out of the district court in the Western District of Tennessee called Hollingsworth versus Tennessee Wildlife Resources. And this is a case about what's known as the open fields doctrine. So this guy, Hunter Hollingsworth, owned a hunting and fishing property. The only way to get to it was actually to cross through the property of two other private landowners. Well, one day he's on his property and he finds this camera mounted up in a tree that's recording his comings and goings. So he takes it down and he takes out the SD card and discovers pictures of these two people who turn out to be government agents, one from the Tennessee Wildlife Resources Agency and one from U.S. Fish and Wildlife. So he files a Fourth Amendment lawsuit. This is procedurally interesting because most of the time Fourth Amendment lawsuits come up when a person has been arrested for committing a crime and they raise the Fourth Amendment as a defense to keep evidence out. Here he filed an offensive Fourth Amendment case. He said, you guys trespassed on my land and that violates the Fourth Amendment. And unfortunately, the district court throws it out under this doctrine called the open fields doctrine. And this is a great example of one of these situations where what you think intuitively should be the law is very different from the way that courts have approached it. So the Fourth Amendment protects your right to privacy in your houses, papers, person, and effects. And what the Supreme Court has said is that the protection for houses, it covers your actual house, and it covers the area immediately surrounding the house, which is called the curtilage. But anything beyond that is open fields, and it does not violate the Fourth Amendment for the police or government agents to enter that property, to post cameras or listening devices on that property. And it doesn't matter what steps you take to keep people off of that property. You could build a 100-foot-high wall around your property with no trespassing signs and a moat full of alligators. And the government would still not be violating the Fourth Amendment by going on the property.
Yeah, I mean, I'd point out right off the bat that I love the fact that this case involves a plaintiff named Hunter and one of the defendants whose name is Hoofman, and involving a hunting property. But yeah, it's definitely jarring for anybody who's not totally immersed in this sort of open fields jurisprudence to hear that if you have a fenced-in backyard and you have a pool back there, that maybe the government sticks a camera inside your fenced-in yard, and if they do, the courts that consider the case will say you didn't have a quote-unquote reasonable expectation of privacy in your fenced-in backyard. It's just one of those situations where you kind of shake your head at the legal creation of saying that situation would involve a reasonable expectation of privacy.
Where does this doctrine come from, Paul?
Well, the idea of the curtilage and open fields doctrine stretches back a long way to the founding. But what I find particularly interesting about the way the law has developed is that we've seen a shift from the U.S. Supreme Court recently towards a more property rights-based view of the Fourth Amendment. So originally, the Fourth Amendment was seen as kind of property rights-based. And then in the mid-20th century, the court started to take a more privacy-based approach. And then recently in a case called Jones, which involved the placing of a GPS tracking device on a car, the court sort of re-embraced this property rights-based theory, the idea that if you trespass on someone's property, that implicates the Fourth Amendment. And the court here tries to distinguish Jones, saying that, well, your car is in effect, so it's covered by the Fourth Amendment, but open fields are exempt, so it doesn't matter if they trespass there. Whether or not that's correct as a matter of law, it just doesn't sound very convincing in terms of what are the interests that the Fourth Amendment is supposed to protect.
Patrick?
Yeah, and I think this is a case where a court is ultimately struggling to adapt Fourth Amendment jurisprudence to the evolving standards of technology that government uses to surveil people. Obviously, when the open fields doctrine was first came into being, there were no video cameras. It was just a person who would be watching you from some distance. Well, now when they can put a tiny camera in a tree or inside a fence or a GPS monitoring device on your vehicle, we really have to confront what it means to have an unreasonable search or seizure. And you find these situations where the court will tie itself a knot saying, well, that's different than putting a GPS device on a car because the car is in effect. Well, what if they're putting a GPS device in your pocket? And obviously the Fourth Amendment also protects privacy of your person. And so if there's a camera that's watching you, or maybe a drone flying over your property watching you, there has to be some further articulation of how this standard is supposed to operate rather than just saying open field, so it's okay.
Paul, could you tease out a little bit the distinction between privacy-based and property-based Fourth Amendment jurisprudence?
Yeah, so the privacy-based theory started to develop actually, as Patrick's pointing out, with the development of technology. So people felt that we needed some kind of theory of the Fourth Amendment that would protect people from, for example, wiretapping. And wiretapping doesn't necessarily involve a trespass onto your property. They can get this information by connecting to telephone lines that are off your property or from central. But I don't know how telephones work. Telephones basically work by magic, but they could get the information without trespassing. And so that's why the Supreme Court developed this theory. And unfortunately, what sort of happened was people started to think, well, that's the only theory of the Fourth Amendment, is that it's really about protecting privacy and not about protecting people's property. As I said, the property-based theory is starting to make a resurgence. It seems to be the theory that has more grounding in the history of the Fourth Amendment and kind of the original public understanding of the Fourth Amendment. So, we'll see what happens with this case. I think it's likely that it's going to go up on appeal, and it's possible that the Sixth Circuit will reverse. It's also possible that this goes to the Supreme Court and they take another step down this road of reinvigorating the property-based theory of the Fourth Amendment.
Okay, that brings us to our final case. Paul?
All right, so we've had two cases where the little guy lost, but this is the one of the great cases where the little guy won. This is City of Philadelphia versus Galdo. And it's just a great case, and it involves another obscure legal doctrine called the doctrine of adverse possession. So back in the 1950s, the city of Philadelphia acquired some property so that it could expand a highway interchange. They used some of that property for doing that project, and then some of it they just held on to, and they didn't do anything with it. It was just a vacant, overgrown field. Then in the late 1970s, this guy, Francis Galdo, buys a house across the street from a particular parcel of this land. And from his perspective, it's just been abandoned. He says it was filled with derelicts and prostitutes, so he decides that he's going to clean it up. He mows the grass, he lays down some concrete slab, and over the next 30 years, he starts to gradually improve this property. He plants trees, he installs a picnic bench, he installs a carport. It really becomes a nice place in the neighborhood. And then a few years ago, the city of Philadelphia comes knocking and they say, well, you need to remove everything from this property because we're going to sell it to a private developer. And that's when Francis Galdo says, no, you're not going to, because I own this property now under the doctrine of adverse possession.
So, yeah, adverse possession is an interesting doctrine in the law that basically says if you use someone else's property under certain circumstances for a certain period of time, the property becomes yours. And Pennsylvania seems to have a pretty long period. It's actually 21 years, I think, from that case. But Mr. Galdo did do all those things for the 21 years. But that wasn't enough for the city of Philadelphia to give up the case.
Yeah, and the idea behind the doctrine of adverse possession, it's really sort of rooted in a Lockean notion of property rights, that property rights arise from your productive use of the property. And so under the doctrine of adverse possession, if someone openly, notoriously, hostilely, and continuously occupies your property, in Pennsylvania it's for a period of 21 years, we give the property rights to that person. And the idea is that we don't want property just lying fallow forever. And so if you have sat on your rights for more than 2 decades, well, it doesn't seem that unjust that the person who's been making productive use of the property does something with it.
Patrick?
Yeah, and it's particularly funny in this instance because the city of Philadelphia basically says just that they would have let it run fallow for that whole period of time. But their excuse for it is that, we have so many properties that we're not paying attention to. It would really be a burden on us for us to have to actually pay attention to the properties we own and see if they're being used by someone else, which, it doesn't really pass the smell test for a reader.
Yeah, exactly. So the argument the city of Philadelphia makes is that we know that the state itself cannot lose property to adverse possession. So if the Commonwealth of Pennsylvania owned this property, Mr. Galdo would have no claim whatsoever. And so the question in this case is, does that also apply to municipalities? And the city of Philadelphia makes the argument that it should, making arguments like what Patrick said, that they own so much abandoned property that it would be a real pain in the neck for them to monitor it. But the Pennsylvania Supreme Court unanimously rejects that argument, and they say, no, there's no reason why municipalities should not also be subject to the ordinary rules of adverse possession. So maybe a somewhat unexpected result, but a big win for Mr. Galdo.
Patrick?
Yeah, and this is an interesting case because although it's not an eminent domain case, there is still a discussion of public use. And the city of Philadelphia takes the position that it's a public use for them to hold the property indefinitely for decades, years, or centuries because they might someday sell the property and make money on it, and that would be a public benefit. And so it just kind of gives you a glimpse into the give a mouse a cookie and he'll want a glass of milk way that governments look at the concept of public use, both in eminent domain and elsewhere.
Yeah, and that's actually an issue that IJ has litigated recently in Atlantic City, where we sued the Casino Reinvestment Development Authority, who wanted to take Charlie Birnbaum's longtime family home, and they wanted to do apparently nothing with it. They just said that they wanted to create a land bank that could then at some point in the future be used for casino-related redevelopment. And we got the New Jersey courts to agree that that is not a public use of the property, and so Charlie Birnbaum gets to keep his house.
Yeah, and we're dealing with the issue of public use in another case. We're filing cert in the U.S. Supreme Court in the wake of Kelo, where the Colorado Supreme Court has essentially given the green light to the concept of one private developer taking another private developer's property directly as being a public use because the private developer themselves says that they might build a road on the property. And so you can see all the different machinations of how this power of eminent domain and the concept of public use can be perverted to suit whoever's needs it happens to want to be suited.
Yeah, and I think that really illustrates the importance of judicial engagement because too many courts just rubber stamp these things without looking at what's really going on. And luckily for Mr. Galdo, that didn't happen here. The court took his claim seriously, and he now has the opportunity to go back to the trial court and prove his adverse possession claim.
Yeah, and that's actually the issue that we're asking the Supreme Court to take a look at because Colorado has now joined a chorus of states that have said as long as the taking is for a stated public purpose, we will not consider the actual purpose of the taking. And so that's the sort of judicial abdication that IJ has been fighting against. There's another group of states, including Hawaii, that have said, no, we're going to look and see if your public use is just a pretextual basis for you to take something for a private benefit. And that's the position that IJ is urging. And it's a very basic concept where we're telling judges, hey, you need to actually judge and look at the circumstances and see if this is actually a public use, whatever that might mean, rather than simply deferring to the person who's saying it's a public use and refusing to look behind the curtain.
Okay, that concludes the show. Thanks for listening. We appreciate you. Until next time, this is John Ross from the Institute for Justice, besieging you to get engaged.